appear to be some minor differences upon amongst the board members as to what duties and responsibilities we may want to bestow upon the county administrator in an effort to create a job description so that potential candidates, as this board moves forward and advertises this job, can have to actually understand what they're being asked to do and what role they would come into. Because the current job description you have is probably a little outdated and needs some update to it. I have asked Mr. Wills to attend tonight to facilitate a conversation. And again, he's not here to lecture the board, he's here to have a conversation with the board. It's a two-way dialogue so that the board can hopefully move forward solidifying what they want to put in a job description for an administrator as that job is advertised. And as all of y'all know, Mr. Wills is the Government Relations Manager for ACCG, and one of the biggest reasons I felt it was prudent for him to come tonight is he offers 14 years experience as an elected official, doing what y'all do, 12 of which was chairman for Webster County. So he certainly offers a whole lot more knowledge than I can ever give to y'all in this particular conversation. With that, I'd like to thank Mr. Wills for agreeing to be here and turn it over to him.
Thank you. I'm assuming you want me to stand at the podium so that it can be recorded. Is that correct? I do appreciate the opportunity to be here. I appreciate Toss extending the invitation on behalf of the Board of Commissioners. And so I said to him, and I'd like to say to you as we begin, I'd like for this to be a dialogue, not a monologue. I'm not here to lecture. I'm not here to tell you what's right or wrong. I'm here to facilitate a discussion. But I do have some points that I'd like to make, and put together somewhat of an outline for the comments that I'd like to share and hopefully the conversation that will be engendered as a result of that. So let me start by saying that Toss has been very helpful and has provided me with two documents which you have copies of at your desk. One is the employment agreement of the previous administrator, and the other is a classification title that was created or last revised back in May of 2009. And so as I read your classification title, read the job duties and descriptions, I compared that mentally with what I generally understand to be the difference between the manager and the administrative form of government. In Georgia, there are about 120 counties that have one or the other of those forms of government. There are more which are administrator than there are manager. And I think that's a reflection of boards of commissioners generally being unwilling or less than willing to give managerial functions in its purest form to a person. There are some counties that have very strong manager forms of government, but generally commissioners like to keep their hands on some aspects of the management of the county government. So in its purest form, a manager form of government gives power to that person to make unilateral decisions on your behalf. In its purest form, an administrative form of government gives the daily oversight to an administrator, but he or she is consistently in contact with the board, and the board continues to exercise a lot of executive function. So with that preamble, when I read your description, it read a lot like a manager's position, notwithstanding that it has an administrator's title. So if you look at that classification title, on that first page, you'll see a lot of things there, a lot of language there that talks about plans, directs, hires, fires, all of those sort of things. And we'll get into a review of that in just a moment. But I think it's important for not just you all, but any county commission to keep in mind what your primary responsibility is. As an elected body, you are the legislator or you are a legislator or you are the legislative body for Effingham County with regard to local issues. In the whole, you can exercise executive function, but in the form of government that you have delegated a lot of executive power to an administrator, and that is spelled out in this classification title. So with that said, it's important for you all, I think, today to have a conversation with each other about what you want your next person to do by whatever title, if you retain the one of administrator, and whether or not you revise the job classification to reflect any changes that you all might agree upon. It's important that you come to consensus, because one of the things that I think is critically important is that everybody has certainty about who's doing what. An administrator can't serve two masters. The people who work for the county government have to know who they report to. Do they report to the administrator, or do they report to the board? Or is there some joint function? There's a verse in Scripture that talks about not serving two masters, and that's true. You certainly can't serve six. So it's important, I think, that you all agree upon whatever it is in terms of job duties and that you abide by that. And that creates certainty with regard to everybody who works for the county government. So with those things said, what I'd like to do is spend just a few minutes and let's go through the classification study, and then I want to point out some inconsistencies between the classification and the employment agreement and the language therein. So if you'll turn to page 1 of the classification title, in that first paragraph titled Purpose of Classification, it clearly says, with regard to the administrator, that he directs, plans, and organizes the day-to-day operation of the county government. That's a very broad term of authority, but it's one that either you or your predecessors, some of you have served long enough that you're probably involved in this, have agreed to in the past. And then if you continue on, it says develops and implements all county policies and procedures. And note, it doesn't say that he approves them, but that he implements or develops and implements. So if
you are again, which one?
Then on page 1 of the classification title, which was the DMG Maximus document. Page 1,
Under purpose.
top paragraph, purpose of classification. And the sentence I was just reading from is the second sentence at the very end, where it says develops and implements all county policies and procedures. So if you were to give an assignment to the administrator to develop a policy for some purpose, it's not then his prerogative to approve it. He has to bring it back to you. You all by a majority vote would approve or disapprove a policy. And if it's approved, then it's his responsibility or her responsibility to implement that policy. So it's important to keep in mind your overarching policy responsibility as a Board of Commission. And then you'll notice at the bottom of that same paragraph, the sentence or the line that is next to the last, towards the end, it says, with regard to this position, directly supervises, it's misspelled, it says supervised, it should be supervises department heads and administrative staff. So this position clearly has oversight responsibility, daily management responsibility, and that is generally what has been agreed upon. And then it gets into more specificity in the following paragraph when you go down below essential functions, not in the bold print, but in the next paragraph that begins with the word plans. And you'll see there are several things: plans, directs, coordinates, and supervises day-to-day operations of all departments. And then it repeats some of that and talks about evaluation in the next line. And then if you continue out to the end of that second sentence, directing work, counseling, disciplining, and then this is important, and this is the third line of that paragraph. Towards the end of the page, it says terminates, hires and terminates all subordinate personnel with the exception of the county clerk and the assistant county administrator. So notwithstanding your title, in the purest form, this would read like a manager's description, not an administrator's. But you have delegated that executive function to the administrator. So you all, I believe, would be well advised to engage in a discussion about whether you retain that language or do you amend it, whatever's in keeping with your wishes. And we'll come back and I know this is thus far a monologue and it will become a dialogue, but I do want to go through a complete review, point out the inconsistencies, and then engage you in a discussion. So if you look on down below that big paragraph into the second one below it, it says advises and informs the Board of Commissioners of any and all problems or situations. Let me just say that the hallmark of a good administrator or manager, if you take two people who are equally qualified, they've got experience, they've got education, they've got all the requisite skills to be a good administrator or manager, but one communicates well and one doesn't, choose the one who communicates well. Because you all need to be kept apprised of everything that's going on. And I don't mean the minutiae, the little things that happen. But a good administrator is going to keep you equitably apprised. And that means that each of you gets the same information all the time. You don't play favorites, you don't count to 4 or 3, whatever it is that constitutes a voting majority. but you count to 6. You keep everybody apprised. To me, that's the hallmark of a really good manager or administrator. You also see in the next paragraph, it says that the administrator develops short and long-range goals for the county. Now, I can understand that sentence or that description in the context of ongoing operations, and you set goals so that we know next week, next month what's going to happen. But the overarching goals of the county are established by you as a board. And if you aren't already involved in some kind of periodic meeting to discuss long-range planning, I would suggest that you do so. At a minimum, annual retreat where you're sitting down and talking about goals that you want to see accomplished. And then you can talk about strategies for achieving those goals. The next paragraph says, with regard to the administrator, that he develops and maintains the operating budget. And then it talks about budgetary function. The single biggest responsibility you have on an annual basis is to adopt a budget. And that budget is a reflection of the priorities of the county commission. Now, I know that sometimes we look at it as sort of pro forma, we go through the motions and we adopt the budget, but I can walk into any county in the state, and I've been to every county in Georgia, many of them many times, and I can look at your budget and tell you where your priorities are. It's that simple. With regard to goals, I can tell you pretty much what your goals are based on what you budget. So it's important that the administrator be involved with you all and vice versa with regard to establishing that budget. In the next to the last paragraph, it says of the administrator, he works closely with the assistant county administrator. Now I understand you haven't had one for quite some time, but I'll point out some other things in that regard in a few minutes. But in the conversation this afternoon with Toss, he advised me that you have 28 departments. That's a lot of departments for one administrator to oversee. If you think about it just purely in a logistical sense, if the administrator were to meet with each of those department heads just once per month, that basically means one meeting per day in order to get them on a cycle and meet with them on a regular basis. That's a lot of information to process. That's a big commitment of time. What you may wish to think about in the future, whether you reinstate the position or hire someone in the position or not, is to find some way to create an organizational chart that gives reporting responsibility for some of those 28 departments up to some subordinate heads who then report to the administrator. That would be a good workflow. Just had a conversation like this last week with the county in North Georgia, going through the same kind of machinations about how do you manage a large organization, and you do have a large organization. If you'll flip over to the next page, just want to point out, and this is really for clarification purposes, if you look about 1/3 of the way down, you'll see acts as finance director. That's outdated according to Toss. You have a finance director, you have a staff, and then 3 paragraphs below, acts as human resources director. You really should modify the job description to reflect that you have people in those positions full time. The administrator would oversee those positions, but you don't need to have the position listed as being the director. So that's clearly something that should be modified. That's pretty much what I want to say with regard to the review there. If you'll indulge me just a couple more minutes, I want to point out some inconsistencies. And here you'll need to refer to both documents, both being the classification title and the other being the employment agreement. And I'll try to go slow enough that you can find these if you want to see them. So on the classification title, at the very top in the right-hand corner, you will see FLSA listed as non-exempt. This is on the first page, top right-hand corner. This clearly is a position which is exempt. It's not non-exempt. I'm hoping that it was simply an error when they described this, but clearly it's an exempt position. And in fact, in section 4C of the employment agreement, which is on page 3, it clearly says in the employment agreement in the second full sentence, Crawley, meaning the former administrator, shall be exempt. So there's a conflict there that needs to be resolved. And it's resolved in favor of listing it as an exempt position on the classification title. The second point that I want to make with respect to conflicts between the two documents is on page 1 of the classification title under the subtitle of essential functions. I've already noted that it says that this position hires and terminates, and it says all subordinate personnel with the exception of the county clerk and the assistant county administrator. But if you look at the employment agreement on page 1, section 2F, which is the last paragraph at the bottom, it says with regard to hire and fire, shall hire and assign, supervise, direct, manage, and then it goes on down to the last sentence, very last sentence on the bottom of the page, provided that the department head shall be hired only with the advice and consent of the board. So there's a conflict here between the two. Your classification title says hires and fires, says nothing about with the advice and consent of the board, but the employment agreement does. So I would suggest that you rectify that one way or the other. The third point that I would bring out is that all throughout your classification title, it assigns various duties, and you've already heard many of those described. But when you look at the employment agreement on page 1, again in section 2, in subparagraph A, you'll see there that it talks about all the duties, or it says shall perform the duties and functions, and it goes on to say as specified in the ordinances, resolutions, regulations, and policies. And then towards the end, basically says as the board assigns. There's not one word in reference to the classification title. I would suggest that you think about amending or creating a new employment agreement with whomever you hire in the future, so that your classification title becomes the predominant document that guides the work of that person. So that's one. The final conflict that I'll point out is that going back to the classification title, it says with regard to an assistant county administrator, and this was down toward the bottom of the page, it says that the administrator will work with the assistant in a close relationship. But it's the board who is given the responsibility to hire that person on page 1, paragraph 1, under the essential functions. So if I read back to that, it says hires and terminates all subordinate personnel with the exception of the county clerk and the assistant county administrator. When you go to the employment agreement on page 1, section 2F, it talked about hiring and supervising all except the clerk. So in one place it says clerk and assistant manager or administrator. In the other one it only references the clerk. So there's inconsistency there. One thing that I would suggest to you is that if ever you're going to hire another assistant administrator and put somebody in that role, it would be well advised for the administrator to be involved in that process. Because if you all make a unilateral decision to hire someone, notwithstanding they might be well qualified, we all know that people have different personalities, and if they simply don't gee and haw, then it can be difficult to work together. And so I think the best relationship you could have is one where there's mutual consent in terms of who's going to fill that position, or certainly give the administrator a say, so that he or she has someone that they feel very comfortable working with. So those are the inconsistencies that I've noted. So what I'd like to do is pause just a minute, ask you for some reflection on that, and more than happy to answer questions. And if you don't have a lot of dialogue in that regard, then we can get into a bona fide dialogue about it. So, Toss, you want to jump up and say something, or you want to capture some points? Okay, he's going to be our scribe today.
I'll agree with what you said, making sure all commissioners get the same information. At one of the ACCG meetings that I went to, and I can't remember, I think it was Stevens County, the administrator, I sat with her, and at the end of each day, she typed up just a small paragraph and emailed it to each commissioner on what was conducted that day. I work a full-time job. Some people can hang out here all day long, and I just don't have the same information until I get my work. So I think that's important that somehow this information is communicated to all of us. We actually had this stuff last week with the fire station. I think, Steve, you were left out of the loop somehow. So I think that's important.
The illustration that I've used in the past about not keeping people equitably informed, and going back to what I said about the hallmark of a good administrator communicating well, is let's say that in the context of the position as it's described today, the administrator makes a decision to terminate somebody. Hiring is usually not as big of an issue, but let's say he terminates somebody. You as a commissioner don't want to be at home not having been apprised of that termination, either whether it was about to happen or did happen, and you get a phone call, and there's a person on the other end that says, y'all just fired my son, and he's worked for the county for 20 years, and you don't want to be in the position of having to say, I'm sorry, I didn't know about it. It would be much better if you've been apprised either that it's coming or that it's happened, given the reasons why, so that when the phone call does come, you can say, I do apologize, but here were the circumstances. You simply don't want to be caught flat-footed.
We have, how many employees we have? 300? There's 28 department heads with an employee count of 300. That seems awful high to me. I didn't realize we had 28 department heads.
I won't
So
offer.
I'm just asking, is that typical? That's a bunch of
I haven't studied your departments to compare them to other counties, so I don't want to characterize it as too many or too few. I don't know the answer to that. I just simply, it's just a lot of people to report to one.
I agree with that.
Dave, over the past years, I don't know if we've been doing it lately, but at one time, and we got some department heads in here, they used to have a department head meeting once a month, and we got some sitting out there to verify this. Whether they've been doing it lately, I don't know. But at one time, they had a department head meeting where all the department heads met with the administrator, and they could discuss what they needed or what they didn't need, or if they had somebody was having trouble with, I guess they would discuss it with the administrator. And then, of course, the commissioners, anybody wanted to come to them, they could, they could show up for them too. But they used to have them regular, and I don't know if they still have them or not.
I'm not nearly as close to your government as you are, obviously, but I can imagine that it's probably happened here. I know it's happened elsewhere. A department head is making decisions with regard to the execution of the functions of that office, and if they aren't communicating regularly with the administrator, even the administrator can get caught flat-footed. So if something's not being done well, maybe it's involving some zoning issue or it's involving something else that tends to be on the controversial side, if it gets into the weeds a little bit and the administrator doesn't know, he can't apprise you all. But it could be that then you have a disgruntled citizen who's on the other end of the phone, and they're calling you as commissioner saying, I'm really disgusted with the way things went on down there at the county office, or they haven't been responsive to me, something like that. You don't want to be caught that way either. Now, obviously, I used to be a commissioner. I served 14 years. I know that things like that do happen. But you want to have enough information flowing between those people who are responsible for the execution of your policy so that the administrator knows what's going on as well. And I'm just not convinced that that can happen very effectively with 28 department heads unless you're meeting with them consistently or unless there's some reporting chain that ensures that there is that level of communication commensurate with the knowledge that needs to be conveyed back to you.
And I can't find it right this minute, so I may be incorrect in this, and I wonder if you saw it when you were studying these two forms. But at one point in time, when I studied this in the past, around the time that the last administrator was leaving, I thought that the employment agreement had some kind of language in it. I thought one of these had some language in it that said, if one doesn't agree with the other takes the authority over it. Did you catch that anywhere?
I don't recall seeing that. I won't say it's not there, but I don't recall that.
And that was my first thought reading through this stuff, is that the classification, the title, was written previous to the employment agreement, and that, back when there was an administrator and assistant administrator. But actually, it shows the last revision of the classification title was after the employment agreement.
That's
May
correct.
2009 and August of 2008.
Rush, do you know?
There's an amendment that the board approved, it's like changing the employment agreement, and that's why that was done with that administrator and the board at that time. I have a copy of it. If you'd like to see it, I can certainly get it for you.
You talked about the one-page amendment in 2010.
Yeah, and that's what drove the change to the thing. I'm not sure what's changed. I was not privy to that conversation. I don't have this description. Well, I have the description, but I don't have any of I'm not privy to any of the changes that you
The change was to the classification title?
Yes, the change was to in the classification, and then there was a change to the employment agreement. I just have copies of them, but I wasn't privy to the conversation.
The employment agreement's changed. The amount of time that if he were to be severed from us, it changed it from 6 months to 12 months benefit he received.
That was a contract.
Yeah, I haven't seen anything that can't be fixed pretty easily.
Yeah.
Just requires your consent to do it.
And it just gets down to which way we want to go as far as if we want how much, what was the word that you used? I wrote down, unilateral, decisions if we want, if we're comfortable with that or not.
Very few counties have a manager in its purest form. I can think of one where literally in the enabling act of the county, the manager is the person. There's just no question about it. But most aren't that strong. And it's because you as elected officials typically want to continue to exercise some direct responsibility. And obviously as a board, as I've already said, your primary responsibility is policy. It's policy, it's ordinances, those sort of things. It's not to go out and direct somebody in the execution of the office. I'll give you an example. This happened in a county in the metro Atlanta area where this was told to me, and I believe it to be true. I'm certain that it is. It came firsthand. But a county commissioner, a district commissioner, went out to the public works crew mowing grass on the right-of-way and said to them, "You guys need to pick up and come to my district." Well, like most counties, they had a crew that was on a rotation schedule, so they know where they're going to start, they know what route they're going to take. You know, they've looked at it from an economical perspective, which way you go. And so now you've got a foreman over a crew that is being told by a district commissioner to pick up and move. Well, who's his boss? Well, literally, that commissioner's not his boss. His boss, direct boss, is the public works director. And the public works director reports to the county administrator, or in this case, the county manager. So does somebody then pick up a crew and move because a commissioner said it? And in this case, the answer was no. The foreman called the public works director and said, "The commissioner just told me." And the public works director said to the foreman, "No, you stay right where you are. We've got you on the rotation schedule. We'll be over there in his district, you know, when the time comes." And then the public works director calls the county manager and says, "The commissioner was just out here and tried to tell my crew to move, but they didn't move." So then you've got a commissioner who's angry, and he feels like he can exercise executive function, but literally from a legal perspective, he can't. So those kind of conflicts arise. I see them from time to time around the state. I would hope they don't happen here. It's an inappropriate role for a commissioner to try to execute policy like that. That's the reason you have a hired staff to do those things. If you are not happy with the way policy is being executed, it can work like this. The commissioner sees that they're cutting grass over there. He thinks they ought to be in his district. So then he goes back to the manager and says, "I don't like that. You know, can you do anything about it?" Well, the manager, if he wanted to reroute it, he could. But ultimately, if you wanted to exercise executive function, you could come back as a board. If you chose, I wouldn't suggest it, but if you chose, you could come back and say, "We're going to establish the policy about how the grass is cut." And if that's what you say, the administrator is going to make sure it happens. But that's too in the weeds. I'm not trying to use a pun with regard to cutting grass, but that's really not what you're about. You said you got a full-time job. You don't want to be worried about where the tractor's running today.
To carry out what we direct.
I often rely on my experience as far as with the school board for 6.5 years, and there are differences, but there are very many similarities with what the law requires and things like that. And here in Effingham County, we did have a strong leader at school board for over 30-something years, and when I was elected, you know, he asked me to come in and sit down and go over some things, just as really a good leader would do, I think, with a new elected official. And he said, you know, to make it clear, one school board member, and it's the same way here, one county commissioner doesn't have authority on their own. We have no authority by ourselves.
Right.
We have authority as a majority vote. When that occurs, that's dictates what happens. And you know, that's pretty easy to understand, although some people don't accept it well, but it's just a fact. And once they understand that, and in that particular case, I think he would have contacted that commissioner and he would have said, "Now if you come to me, I'll get that work in the rotation, but here's how we got to handle it."
Right.
You know, and he was just a strong, good enough leader that along the way he kept the majority of commissioners informed, and they kept him in his position. But he was a strong leader, and he didn't just allow all kinds of stuff to be going on. But by the same token, we had ability. He could not hire and fire anyone without a majority vote of ours. I can't think of an instance when anyone actually went against his recommendation because they respected him. But there could have been a case. There were a couple of cases where it almost happened, So, you know, there are things I think that we need input into, and if we give all of that input away, then for myself, I don't feel like I'm representing the people that elected me to represent them. If I give it all away to one person, there may be a time that I'm not able to have happen what I need to happen to speak for those constituents properly. That's how I feel about it.
Whether you resolve it, or whichever way you resolve it, whether you give the administrator unilateral authority to hire and fire without advice and consent, or whether you reserve advice and consent, that doesn't matter to me. It's just important that you rectify the differences between the two documents. I think that's what's important. Advice and consent, we're familiar with that from the federal level with regard to presidential appointments. But even if your language didn't say advise and consent, going back to what I said about the hallmark of a good administrator, he would do that. Even if he had the power to make those decisions without your consent, he would nonetheless be picking up the phone and calling each of you and say, hey, I was thinking about hiring Gary to fill this position. I want to let you know, you have anything you want to add? That's what I would do if I was in that position. I would never try to use that position to its fullest because I would recognize who I work for, number one, and number two, realize that you as a board are going to either enjoy or suffer the consequences of the decisions that I would make. And I would rather for you to be apprised and give me your advice and consent on the front end than to have to deal with the wrath on the back end. Mr. Chairman, I don't want to belabor the point about the two documents, but if there are other questions, more than happy we can continue the dialogue, but whenever you're ready, I'd like to talk to you about process with regard to hiring. So your call, sir.
Clarify one thing for me. I know that you said there's 120 some counties in the state that have some type of an administrator or manager form of government. Is there, in our document, our classification title is more attuned to a manager form of government than an administrator form of government?
It reads like that, but you're not unique.
I understand. Is there any significance? I know in going to training seminars, there seems to be some distinction because they say this many counties have a manager form of government, this many have, and then an administrator, and then they said, and most have some type of a hybrid in between.
Right.
Which I think that's what we have is a hybrid.
Correct.
But is there any significance? Do we have to declare what we have? I mean, is there anywhere in the governance of Georgia that says Effingham County has to declare whether we have a manager form of government or administrator form of government? I know if you've got a sole commissioner or you've got those are different.
I'm not aware of any place in statute where it says that you must, but your enabling act, which I have not read, probably specifies your form of government with regard to being an administrator. You can use there are two basic ways that, pardon?
It's my understanding we don't actually have an enabling act. Is that right?
No, every county has an enabling act.
We have a series.
It's done in pieces over
I
time.
have an email from our county attorney that says we technically don't have an enabling act, but we have pieces, I guess. That's how it was worded to me, that we didn't technically have one because I asked for it.
Well, it's
All right, well, let me just, go ahead, Tom.
I'm sorry, I was just gonna say it's over pieces over, it's in pieces over years, and it does specify that we have an administrative form of government.
That works at the pleasure of the board. I think it kind of left it
Can I
at
get a copy of all
that.
those?
Something to that effect.
Yeah, if we have them all. We pulled a bunch of them, but I don't know if we pulled every single revision. It got a little complicated as to how you follow it. And we got some of the judges involved, and I think we even called the state.
Yeah.
I guess that's the email that I get that says we don't exactly.
As one of Georgia's original 7 counties, that our enabling legislation was literally, it shall be established Effingham County, and its border shall be, and then after that they said, each county shall elect from its members, and then it just kind of keep going piecemeal. If it's a newer county, it'll say everything in one place. We do have a list
Are
from
we
the,
actually saying we don't have that in a book somewhere with all the pieces in order so that we understand our full enabling acts? Is that what we're saying?
I would be surprised if it exists that way. I've looked at several of these for counties around the state, and typically what you see at some point when the county was created, and then thereafter, there were amendments made to the original enabling act. So when you refer to the enabling act, it's generally plural because it has many pieces, much of which has superseded something in the past. So,
But you typically keep a book with the amendments added to it, would you not? I mean, how do you know what you've?
there is a book. In fact, there are many books. But what you have to do is take an index of local acts, and then you have to refer to which ones are still current or active. I recently did this for a county, and the most recent, the latest in time, the earliest in time act that was active started in the 1930s, and the most recent change to it had taken place just a few years ago. The most common change you see is with regard to redrawing your districts. Now, in your case, you've had some changes to your enabling act via creation of the chairman's position and some modifications to that over the last 4 or 5 years. But typically, and it gets to be a real convoluted process, you would have to find the earliest in time active piece of legislation and everything thereafter, and you would literally have to lay them out on the table after you photocopied it, and you would have to laboriously go through and figure out which ones are still active and literally cut and paste and tape together until you had a readable document, and it would still be a stretch to say it would be understandable in a very easy format.
We contacted Legislative Affairs and Legislative Council, and they provided us a list of every local act affecting the Effingham County Board of Commissioners. There's acts that created a county tax assessor, a county tax commissioner, the elected positions, each one of those little things, like the county surveyors in there, all these little pieces, some of which have now been nullified, county surveyors being one of them. So it is like you say, just a list of different enabling pieces of legislation affect. And we have that.
When did you obtain that?
When?
Yeah, 2 months ago, 3 months ago.
When we were going through the board procedures, we wanted to make sure that we were consistent with state law when we created the policies or the policy and the piece particularly that had to call meetings, a procedure for that, or any other piece. We just wanted to make sure we had it. So within the last couple of months.
As somewhat of an aside, and then we'll move on, ACCG is actually working on a model or a template for an enabling act. And once that's released, hopefully a lot of counties will utilize it and update so that you have a very readable document. With regard to the current conversation, the question was with regard to whether your enabling act specifies the administrative form of government, and the answer was yes. And so in that context, there's no statutory place that I'm aware of where it says you must name it, but there are 2 basic ways that you create your form of government. One is through the Enabling Act. It can say that you have a manager or an administrative form of government, or neither. It can say tradition, a regular commission, whatever it says. But the Board of Commissioners has the authority under statute to create and appoint a manager or an administrator. If it's done through a local act, then there's no need for you to do so through a local ordinance. So it's already been established for you that you have an administrative form of government. If you wanted to change that for some reason, I would suggest that you talk to your local legislative delegation and get them to buy in on whatever you want to do.
Ms. Wills, in the ACCG handbook, it actually specifies that local legislation can create the office of a county manager or county administrator if the one is non-working for the board. So that means if it was a county administrator in our enabling legislation, you could create the office of a county manager and change that, correct?
Correct. The board can exercise its own rule powers in that regard, but you don't have to. If it's already been created through local legislation, there's no need for you to act. If you wanted to make some amendment to it, I would recommend you confer with your county attorney about process.
Well, I think all of that is just answering the basis for my first question was to just lay the foundation for this question, because it sounds like the bottom line is we call it whatever we want to call it. We just simply outline the classification and what we want the powers of that person to be.
That's correct.
Okay. And we could call it whatever.
Well, except in the case of the ACCG handbook, it kind of specifies that you call it a manager. You typically give that, there are some categories it tends to follow, and you call it an administrator, and I think that would be a safer thing, that it kind of make a decision to stick with what the ACCG book says that we go with, like try to call it the right thing in accordance to if you're giving it unilateral power or not.
Lee County, Georgia recently went through this same discussion, and they actually changed the title of the position from administrator to manager because it read in a way that really described a manager's position. I'm not here to advocate that you change anything other than correct the inconsistencies that I've noted. If you chose to do so, you could, but that's really not the most important thing. The most important thing is a clearly written classification so that whomever you're going to hire has a legitimate understanding of what it is they're expected to do. That's the bottom line for me.
And that's the way it sounded. The outline of the document, the job classification title is more in line with what a manager position would be as it is written now. However, I think this board is going, and this is my opinion, I think this board is going to have a problem with calling it a manager. So we look then at the classification and make it coincide with an employment agreement to narrow, to very specify what this board's opinions and desires are for that position.
Yes, sir. In pointing out the inconsistencies between the two documents, it's not my intent to say that you have to change something with regard to the employment agreement, but rather to say that you need to change the classification title and ensure that the next employment agreement you enter into is consistent with it.
And
that's what's important.
Excuse me, and that's my purpose for this meeting is, and we need to start advertising for someone to fill this job on a permanent basis. And I think the worst thing we could do is try to fill that job with an outline of what's expected, and whoever we hire doesn't have a good, firm understanding of what's expected of them. And for this board to have a good, firm understanding of what we expect of them and how they're going to be held accountable for the job that we hire them to do.
Correct. And I would add to that, and certainly not in a disparaging way, and what you expect of yourselves. Because the Board of Commissioners really is the body which sets the expectation, not only for the administrator, but for the way that your entire county is going to operate.
And to tell you your example of the commissioner going, hopefully that's not happening now, and I don't think it is, but there was a time in this county that did happen. I mean, you'd have a commissioner go by and send them to one place, and then that one go by and pull them off of there, and they might move 3 times in the same day and never get anything done. But I think this board all understands that's not our position. We have people hired to do that.
Well, and I was going to mention between the two differences, while I understand Chairman Kessler's point is that the classification study kind of leans towards more of a manager type explanation. Like when I first came on board, the first thing in a meeting that I had with David Crawley at the time, he gave me a copy of his contract. And so I had read through that and was privy to the fact that we did have input on department heads, which was something that was important to me, but I did not know there was a job classification that said otherwise. So I learned that more recently. But so while one has more of a managerial, the other has more of an administrator, and that's still where we have to get the balance of deciding, setting which one we're going with, which way.
Are you ready to talk about process?
Go ahead, sir.
All right. Well, let's assume for a moment, and I think it's not unreasonable to make this assumption, that you all are going to come to agreement about what's going to be in that classification title. So once that's done, and I would highly recommend that you have that done before you begin to advertise the position and you get into the hiring process. So one of the first things that you've got to decide with respect to process is whether it's going to be driven internally by you and your staff, or whether it's going to be driven externally by a consultant that you would hire. And I would also suggest that there is a difference between what I would characterize as a passive approach and a proactive approach. Passive in this regard, you come to a conclusion about the classification title, you prepare the job description, you post it out on Marketplace, which is the joint site for ACCG and the Georgia Municipal Association, and you put it wherever else you're going to advertise it, locally and otherwise. And you simply take what you get. If you get 20 applicants or 50 applicants, then that's what you pick from. That's a passive approach. A proactive approach is one where you actually have, either with your own resources or an external consultant, a recruitment process. I know that in a county not far from here, they are actively recruiting. They're calling people. And I've dealt with 2 of the people who they're recruiting. And they're saying, hey, this position is coming up, and we're interested in knowing whether you would be willing to come work for us. We'd like to talk to you. That's the proactive approach. I'm not here to recommend one or the other. I know which one is more costly. The recruitment process, if it's driven externally, is more costly. And I'll give you an example here. A county in southwest Georgia just a few years ago hired an external consultant, and I believe that they paid about $30,000 for this firm to come in and do the work. They actually produced a very slick, glossy production that was then sent out to the various people that they were recruiting. And it was also an open process, so it was all comers, but they had a recruitment component to it. But it cost them a lot of money, and they ended up hiring somebody from out of state, and the gentleman stayed for 2 or 3 years and then found another job that he was more interested in and moved on. In the subsequent process to replace that administrator, they decided to go back internal. They did use the resources of the Carl Vinson Institute of Government to do some vetting of candidates, but as far as the recruitment process, they didn't engage in that, and they didn't spend very much money. So it's really your decision about what you want to do. Understand that you have an HR department and they're capable people, and that they can help you in this regard. I'd be surprised if you wanted to spend $30,000, but notwithstanding which one you choose, be committed to it. The key is to make sure that that job description is prepared and that it reflects what is in the classification title, so that when that candidate who potentially would offer him or herself comes in, they can say, okay, I saw in the job description that it says thus and so. What else can you show me? I want to see, is the classification title out there online, or can I get a copy of it? Can I read that and be prepared so that I can understand what the job responsibilities are? So prepare that job description. Obviously, you're going to advertise. I just mentioned Marketplace. There are a number of other places where you can advertise, but Marketplace with us is free. It's well known. It's looked at a lot by people who are in the market. But I would strongly recommend that before you ever put the advertisement out there, that you define your process, not just in terms of what you're going to do, but when you're going to do it. If you put that job description or that posting out there, you want to know, candidates I think want to know, when this is going to conclude. Are you going to leave it up for 45 days or 60 days? I don't think I'd go longer than 60 days. I probably wouldn't go any shorter than 30 at a minimum, but I like 45 to 60, so that people have adequate time to see it, to learn about the county, to offer themselves as a candidate. And then on the back end, you need to also, in my opinion, define your time frame. Now, if you need to modify it into the process, that's okay. But if you say we're going to accept applications, I'm just going to make up some times here. We're going to accept applications through January the 5th of 2014. And you internally, you don't have to tell this elsewhere, but internally you say, okay, we know that by February the 5th, we're going to have gone through the initial review of all the applicants. And that by February the 15th, we'll have it down to 10 candidates or less. But put some time parameters in there so that you have a calendar that's driving events. If you need to modify it, if you find out there's some extenuating circumstances that would require you to push that out, by all means do that. I'd rather see you take more time than make a hasty and perhaps incorrect decision. But if you don't define the process up front, what tends to happen is people procrastinate. And so, well, we didn't deal with that last week, but we'll do it next week. And then next week is next month or next quarter, and I've seen worse. So I would suggest strongly that you define with regard to date certain when you want things to happen. If you're going to use your HR department, make sure about who's going to do what, whether it's your HR or some external consultant. But here's some things that I highly recommend. With regard to your applicants, validate the information in their application. Now, I don't necessarily mean every little jot and tittle, but if they say that they're a graduate of XYZ University, see if they're a graduate. We've had some well-publicized examples in other circumstances where people didn't tell the truth. So make sure that you validate their information. Check their references. Obviously, people are going to list references which they think will give them a good report, but you still want to check with them. check with their past employers. Now, in the business that you're in, and that those who offer themselves generally for manager or administrator positions are in, sometimes the past employer doesn't give a good report. And I know that's the case. But I would suggest this to you. If one of your leading applicants has been forced out elsewhere from a city or county, it doesn't mean they're not a good manager or administrator. It just means there was something that caused them to part ways. I can think of a couple of people right now who have been forced out of positions in county government who are good managers and administrators, in my opinion, and they were forced out for political reasons. It had almost nothing to do, at least in my opinion, based on my limited knowledge, of their skills and the job they were doing. But I've seen it time and again, and it will continue to happen. There's an election, there are new board members, someone is not happy about the way something's been done in the past, and they ask the administrator or the manager to please leave. And the good one will say, be glad to, it's been fun working for you, and I look forward to the next opportunity. Sometimes it's not quite that smooth, but don't necessarily push someone aside. I will tell you this in terms of trends. My observations over the last 5 years has been that there are relatively few, in comparison to the number of openings, people moving laterally or upward in the ranks of county management. And I can't say what the reasons are necessarily, but more people are coming from other disciplines into county management than moving within county management. Bankers, CFOs, just a number of people that have been hired around the state that had zero public sector experience, and they're being hired because they otherwise had credentials which looked good and the commissioners thought were good. So you may get a lot of candidates who don't have public sector experience. I would encourage you not to push them aside just as a matter of function, because they may be good folks and they may have the skill sets that you're looking for. Another thing that I want to strongly emphasize is that when you get down to that handful of people, whether it's 3 or 5 or 10 that you get serious about, do your background checks, including criminal background checks. And I share this story. It came out of a city, not a county. They hired a downtown development director. They had an external firm doing the work, and somehow that firm, it's a very reputable company, somehow they missed a criminal conviction in this guy's past. They hired him, and he perpetrated the exact same crime, which was basically taking money from the government. And when he was caught and arrested, then the previous conviction came to light. And that left a black eye on the city manager and the city council and everybody involved. So I strongly encourage you to do a thorough background check. There was an example not very far from here of somebody being hired. It's been, I don't know, a couple of years back. I lose track of time, but being hired and staying on the job for less than 2 weeks because something arose from his background, and he decided rather than stay, he would leave. And so you don't want to be in that position either. So make sure that you have people who know what they're doing to conduct those background checks and do a thorough job.
You had mentioned that ACCG has a vetting process or some kind can assist. What do y'all have to offer?
If I said that we have a vetting process, I misspoke. I don't think I said that.
Carl Vincent.
Oh, okay. I'm sorry.
Carl Vincent, they come at a fee. I don't know what they charge. They'll rank your candidates if you want them to. But no matter who you hire, or if you use your own internal staff, just make sure you do a thorough background check. People sometimes look good on paper, and they turn out not to be in person, and vice versa. So it always requires the personal interaction. And the best people that you can get to give you references, to really get the skinny on folks, is to find people who know, that have worked with them. That's the best people, I think, to talk to. Once you get through that part of the process, you're obviously going to get down to interviewing candidates. I have emailed, I think Toss has probably got this information, I've emailed a list of potential questions. I would strongly suggest that as you enter into an interview process with whomever or however many people you select, that you think about that as a two-way street. It's not just you asking that person questions. If I was on the other side, if I were being interviewed by you, I would be asking you questions. I would want to know how well you work together. I would want to know what your priorities are. I would want to know what it is that you're focused on, because those things make a difference. Even when we disagree with one another, can we agree to disagree? Can we walk out and still have a cordial conversation? Or is there so much animosity that there's just no way that you can ever cooperate? I would want to know all those kinds of things of any county that I was going into. So look at it as a two-way street, an opportunity for you to have an exchange of information, not just a monologue. So make sure that you're prepared for the interviews well. And then with regard to the process and whether it's opened or closed, there is nothing in Georgia law that requires that you go behind closed doors to interview any candidate. You can review the applications in public meeting. You can interview candidates in the public meeting if you choose to. The advantage of doing that is that when you reach your decision, you can say, Mr. Chairman, you can say, anybody want to offer a motion? Motion second to hire this person, vote on it, and you've hired them. If you go behind closed doors, which is allowed as an exception to the open meetings law, and you interview these candidates behind closed doors, then the stipulation becomes you then, before you can vote to hire anybody, you can name up to 3 candidates. You don't have to name 3, but you can name up to 3. And once you do, you must wait for 14 days after having announced it before you can make your vote. And that's to give people externally time to see who it is that you're considering. And sometimes things arise. And sometimes we see people withdraw from a process once their name is public. But that's the difference. So you can go behind closed doors, but you must wait 14 days before you make the final decision to hire someone. So with that, let me make 3 more brief comments, and then if you've got questions for me, I'm glad to answer them. With regard to residency, I noted in I believe it was in the employment agreement, it said that the administrator would be a resident. I would encourage you to leave that out. You can encourage it, but you can't require it as a matter of law. With regard to relocation, this has been a big issue, although it perhaps is beginning to wane a little bit as the housing market recovers. But over the last 4 or 5 years, there have been some pretty good managers who would perhaps have moved elsewhere, but they chose not to because it was simply hard to sell a house. And if you think about the average tenure of a manager or an administrator in Georgia, it tends to be somewhat short, although there are certainly many exceptions to it. But let's say that I'm in County A and I'm thinking about possibly going to County B, and this could be an example for you. You're a progressive community, you've been growing a lot, you're going to be attractive, I think, in terms of opportunity. So you've got the candidate over there who potentially would come to you, but he's got a mortgage, or she's got a mortgage. And so now you're talking about having to relocate some distance and buy a home. Can you support 2 mortgages? I know this happened to a friend of mine who moved for a pretty good increase in salary, but he got saddled with 2 mortgages for about 1.5 years, and that was tough on him. He told me it was the worst financial decision he'd ever made because he simply got stuck with a house that was underwater and he couldn't unload it and get out from under it. Now he did eventually sell it, but I think it took him about 2.5 to 3 years. So as you think about the candidates, that's probably one of the things that you may want to engage with. When you get down to your final few, relocation, are they willing to come? Do they have a mortgage? How difficult is it going to be? Because it could influence the decision that person would make. So give that some consideration with respect to the housing market. And then the severance package. You obviously had an employment agreement which required or called for a 6-month severance. I think I heard someone say earlier that was changed to 12 months?
To a year.
Yeah.
To a full year? I've seen some information that was collected in a survey of managers, administrators from around the state. It was not a scientific survey. It wasn't a poll type exercise. It was simply a voluntary survey. But the average appears to be 3 to 6 months. You see a few that's 3, you see a lot that are 6. You very seldom see any that are longer than that. I'm not here to suggest what the length of the severance package ought to be, but I have heard some commissioners say, well, we're just not going to offer a severance package. If you don't offer a severance, it may be an impediment to someone coming who otherwise might. And the reason is because it's not like I can leave you today. If you ask me to resign my position, I've done 5 years or 10 years of good work for you, and there's been an election and somebody's not happy and you ask me to leave. It's not like I can just pick up my bags and be working somewhere else tomorrow. So that severance package acts as somewhat of an insurance, if you will, and allows for some certainty with regard to paying bills during that interim period when I would go out and be looking for my next position. So, Mr. Chairman, those are pretty much the remarks that I had written down. If I missed anything, and I'd encourage you all or Toss or Adam, anybody to point out any omissions that I made.
Educate me, when you said that if we did closed door interviews, then when we narrow it down, we have to narrow it down to a minimum of 3?
The law says that you can name up to 3 finalists. It does not say that you must name 3, it says up to 3. And occasionally, not usually, but occasionally, I see a county that names 1 and says this is our sole finalist. So it's a foregone conclusion about who it's going to be, but you still can't vote until 14 days has expired.
So then you advertise that and allow 14 days for public input.
Yeah, it's a press release to your local media, whoever covers you.
Now, what level of employee is that limited to?
It's for executive positions. What I want to do, instead of trying to explain it, because I haven't read this in the last day or two, but in the ACCG handbook with regard to open meetings, open records, there's a discussion about that. I don't know that it's ever been clarified in case law, but it's basically executive functions. So department heads, certainly the administrator.
Will a clerk qualify as that?
I don't think so, but I don't want to say with certainty.
Okay.
I'd rather refer that to your attorney.
Well, that question came up before, and I think the clerk's position did not apply to that.
The clerk, in my opinion, doesn't have executive function.
Right.
It's purely administrative.
It's typically just pretty much been used for the administrator, has it not?
That's what I generally see,
As a precedent.
but I think it could apply to other positions, department heads that have executive function.
Now, would your opinion, if this county was to have let me think about it. We don't have an assistant administrator now, but if we had an assistant administrator or manager, does that person need to answer to the board as well, or does that person answer to the administrator or to the manager?
My opinion is it would be best if they answer to the administrator. And the reason is because conflict can develop if you have 2 people who are required to work closely together, but the subordinate doesn't report to the superior, instead reports to the full board. So I would say they ought to report to the administrator, and ultimately the administrator is directly responsible to you.
I was just asking for your opinion. Board, do y'all have any questions?
He covered it pretty good, and I didn't know if there was this much difference in this classification and the employment agreement. Like I say, you pointed out the difference in them, and they contradict each other.
Let me ask you this question. You have the assistant administrator, so we have one, and he's reporting to, and I agree with that, exactly what you said. But in the instance that you have an assistant administrator that happens to become knowledgeable that there is information that should be being given to the board that's not being given to the board, or completely inaccurate information being given in a public meeting and it's not given to the board, then at that point in time, what becomes that employee's responsibility?
My opinion, to put you off the hook for
Well,
just a second
you're
while
not
you're
getting off the
thinking. No, you're not getting off the hook, but any employee of this county ultimately works for this board, and any employee that sees anything, whether it's illegal or inappropriate in any manner, if they can't get it to this board through the employment channels, I think they have an obligation to present it to this board. That's my opinion. Whether it's an administrator title, assistant administrator, or whether it's human resources, or whether it's finance, or.
But if they've been directed by, say, inviting by email, that they are only to report to that person, then, and that person is their.
I believe they
Let
become
me
a
suggest-
whistle. They become a whistleblower.
What,
Let me suggest that there might be an analogy, and I have not reviewed your personnel policy, But typically in personnel policies, when there has been some abuse or incident, it's generally reported to the superior officer in that department. So let's say it's in public works and two guys have some quarrel and one of them punches the other. That typically gets reported to the public works director or whoever the department head is. If it was the department head who struck the employee, then who would it be reported to? So it would then leapfrog. So the employee who was struck wouldn't report it to the public works director because he was the one that committed the infraction. Instead, it would get reported to the administrator. So in the context of the question that you asked, it might be that if there is some incident or infraction that needs to be reported, that a policy, personnel or otherwise, that's been adopted by the board might guide that process so that it then gets reported directly to the board, leapfrogging the administrator who is the problem or has created the incident.
And I ask the question because, you know, I want employees of Effingham County to be able to feel like that, just like any citizen, they can come talk to me about a problem. And I know that there have been some people that felt uncomfortable with that. So I do think we need to provide clarity on that issue.
So let me go back to the conversation we had about your primary responsibility as policymakers, setting legislation for the county. If it became a standard practice that the employee, some disgruntled employee or one with a concern, was going straight to a board member instead of to the department head or the administrator, I suspect that you all would be answering the phone every day about someone's pet peeve, that something's developed, and you would tire of that. It would also undermine the structure of your government. It would undermine the accountability process that has been built, whether formally or informally. So I'm reluctant to suggest that employees ought to come directly to commissioners unless there's some extraordinary circumstance. And specifically, I would say they probably ought not come to you all unless the chain that has been established has failed to work. And at that point, clearly they should come to you. But I think that can be addressed in policy.
Yeah, I definitely didn't come to us first, but I do believe that they need to be able to.
When I was in Athens not long ago, Forrest and I were up there for training. It didn't take very well, but I was there. The Human Resources Director for Athens Clark County was there, and he gave a lot of good examples of policies that they had put in place, and I think a lot of them were well worth noting. But the one that I especially took notice of was his statement that their manager would never go and fire somebody without first coming to Human Resources first, to pull the jacket on that employee, be sure all documentation was there, everything was there for the basis of firing that person. So even a manager needs to understand that before taking action, sit back. That's what I used to always tell my dad to do before whipping me. Step back and be sure you got all the facts. Didn't work well sometimes, but that's what we need to do in government as well, regardless of what we, and that's this board's function, is to be sure those policies and procedures are in place, to be sure that those things are followed so that we don't get ourselves in trouble.
Harry Owens, the gentleman you're referring to, was telling you about another manager who truly is an excellent example of how you can survive and for long term. And that's the reason that Alan Reddish has been in Clark County for so long, because he's that good. He understands it.
It sounded that way. Didn't have the opportunity to meet him, but it sounded like somebody I'd love to have here.
He's a very good manager.
You know, the problem, and it's not a problem, but Effingham County has just grown so much through the years, and sometimes policies and procedures and things, we try to keep things as they were. And we're, 55,000 or so, you just can't do it like you could when it was a 10,000 population county.
Mr. Chairman, I made a comment to Toss earlier this afternoon that, it wasn't to Toss, it was to your new clerk, that oftentimes in counties like yours, conflict develops, and it's because you are like some other counties in Georgia where you've had rapid growth, and rapid growth always leads to problems. It leads to contention between those who have been here and those who are newcomers, and changes in ordinances and zoning policy. Those sort of things lead to conflict. So I think that it's not something that you should look at and say, this is a problem that's going to afflict us forever. But instead look at it as an opportunity, as a challenge. A good manager would understand those kinds of issues and be prepared to address them. It should not be an impediment with respect to someone offering themselves as a prospective employee of yours as administrator.
But we have had growth and we've had a breather. A lot of folks don't like the fact that we've had a breather because of the economy. But, I was looking at lot inventory in this county, and good lot inventory is going down. Houses are being built, our building department is functioning to capacity, trying to keep up with permits, and that's a good thing. But we are looking again towards growth. So we need to take this breather and get our policies and procedures for the next run of what I think is ahead for Effingham.
Well, with regard to your process, however you all choose to proceed, if I can be of assistance to you, I will. Certainly, Toss, any of you are welcome to call me and ask questions. I'm more than happy to help in any way that I can.
Any other questions?
Y'all didn't throw one thing at me. I'm proud.
Sir?
You didn't throw one thing at me. I'm proud.
We're nicer than you heard.
Pardon?
We're nicer than you heard.
I hadn't heard anything there.
David, is very many prior military people looking at these type positions? I know there's a lot of people coming out of the military that's got a lot of managerial experience.
There are several managers or administrators in Georgia who have military background, including many officers and are retired. Yes, sir. Yeah, I can think of retired colonel out of the Air Force, retired colonel out of the Marines. Yeah, there's several. I don't have a listing of them, but probably 7 or 8 at least.
The previous one here that was Mark Crosby.
Any other questions, comments?
No, I just think we need to have, for our board's perspective, is time frame of getting this classification title nailed down and moving into the next process.
Will it be okay with the board to direct staff to make these clarifications and try to get these differences put together?
Well, they'll probably need to know which way they need to get it. But I guess get it in one document and then
Let's get it down to one document to present to this board for review, and then let's make whatever changes we see fit to make. And that might not be the right way, but I think the first thing is let's get the discrepancies separated and get one good document. And then we can look at the tweaking of responsibilities.
Yeah, I think simply you get the classification title straightened out, and then any new contract is just rewritten.
Right.
You know, with new terms.
Whatever certain things that were addressed, like where it says it's not non-exempt and needs to be changed to exempt, any of those kind of things that were brought up, that was obvious changes, you can just make
And
those.
some of that may be handled in this amendment that you were talking about.
And to be simple, you can throw the previous employment agreement away and then you have one document.
That's right.
That's simple, and then.
If we get the classification right, basically then all the employment document is the severance and how much you're gonna get paid and how you get compensated to do this job.
Well, I actually studied this before.
Correct.
Today I caught for the first time those two sections of severance in the contract.
The second one was an amendment done a couple years later. Would it be a safe assumption to say that the board would prefer the duties out of the job contract more so than the job classification, meaning hiring and firing abilities and so forth?
For my vote, yes, that's my position.
I mean, I think that's what I've heard in the past, I'm just, so that we can get a direction to clarify this.
saying
That we have input on department heads.
department heads, not,
I don't have on everybody, just like the person says, department heads.
okay. But wouldn't that be dealt with in the classification, not in the contract?
Well, that's what I'm referring to.
Yeah.
Chair, just take the language from the contract into the
Turn the
classification.
agreement into a classification.
You got it?
Yes, sir. Are there any other things that stick out in y'all's minds that you want to make sure either are or are not included in this?
I could email you mine, and then you can highlight them in or out.
That's certainly fine if y'all want to do that, and we can highlight the differences, and then anybody else obviously that has input.
I would suggest that any board member make those highlights and send to them. The only thing that's gonna have to come before this board is a final document. We can have whatever discussion back and forth to agree with this classification. And then come up with, we will vote to accept that, and then we move forward with the hiring process.
Yes, I think the first step would be, as Mr. Will said, let's get the job classification so we know what we're posting, and we can move forward and work on it.
Once we have a document, then you can go ahead and email it so we can be.
Yeah, once we have one, then Rush and I can work as far as scheduling and so forth, we'll get together. And I believe she had previously talked about being able and comfortable to handle this internally, we'll certainly bring that to the board, but we can get a plan on that together.
All right, anything else?
Thank you.
Thank you again for coming. You're welcome to stay for our, we'll be here probably till about 11 o'clock.
I might take a pass then.